Good evening, Judge Newman. As you may remember, I began my testimony with a creative oath about my religious belief. I affirmed that the Bible contained the gospel of the nonviolent one, Jesus, who illustrates perfectly for those willing to take the risk of following him and his example that truth is nonviolent and that it always acts to subvert the lies of violence that the empires of the world would force us to live by. I want to continue in that vein very briefly. Jesus promised to send a Holy Spirit he called an advocate, the literal meaning being a defender in court for those who are required to give reason for their actions. When you see concrete actions that signal liberation from the lies of violence, stay alert, stay awake. Do not disparage or worse, criminalize such activity. Do not call something that is good evil. To do so is to be bypassed by grace. To deny the work of the Spirit is the hardest thing to forgive. Today may be the last chance that any of us has in our brief life to cooperate with the work of the Spirit. Ed Canan opened our defense by noting the convergence of the path of legalism and that of justice lit by the light of conscience in our case. I wanted to end with a kind of charge to the jury with a few brief points of law that illustrate this convergence. I have to say I got this idea from Judge Jokel, who began his decision in a previous case by reading a charge to the jury to let us know he was holding himself to a similar standard. The Charter of the International Military Tribunal, commonly known as the Nuremberg Tribunal, was an executive agreement signed by the government of the United States in 1945 and is binding upon the government of the United States, its civilian and military officials, and its citizens as a matter of customary international law. Any person, whether a member of the armed forces or a civilian, who commits any of the following acts during peace or war commits a crime against international law. And I'm not going to list all these crimes and violations of international law again for you. The fact that domestic law does not impose a penalty for an act which constitutes a crime under international law is not a defense to a crime against international law. If you find, from a consideration of all the evidence, that the defendants reasonably believed that conspiracy to commit crimes against peace, war crimes, or crimes against humanity, or complicity therein, was being committed by civilian or military officials of the United States, and that the defendants acted out of an honest belief that they were privileged under international law to take reasonable steps to uphold international law, and the acts committed by the defendants in this case were such reasonable steps, you must find the defendants not guilty. As I said before, this is the defense. This defense, or the one that Judy spoke to just now, where international law is applied seamlessly to a state statute, I believe most of the defendants' preferred defense because they have the most potential to save the lives of drone victims, which was the first concern of our action. Thank you.
Okay. I'm going to go through the list again. Martha Hennessy was not right. She is there's no closing.